we're going to go ahead and get started just so I can be mindful of your time. Today, we're going to be talking about estate planning in a time of crisis. What are the 7 costly mistakes that families are making in their estate planning? And we're going to have a special emphasis today on the basic documents that every family needs during this crisis. And it's not just every family. Every individual over the age of 18 must have basic estate planning in order so that somebody could step in and help them. And we're going to talk about what does that basic estate planning look like. So, I mean, this slide goes without saying, these are perilous times in the United States as well as in the world. We are fast changing the way we live in society and the way society functions. And so we really do need to step up and get some of this stuff in place immediately. I use California numbers here because Governor Newsom is really the only one who's given us these estimates so far. California Governor Newsom estimates that 56% of all Californians, which is 40 million residents, will contract COVID-19 by the time that this is over. 56 people contract coronavirus. That is 22.5 million Californians infected. If 20% of that number get severe disease to the point where they have to be hospitalized, that is 4.5 million Californians who will get very sick before this ends. And if 1% of those pass away, right, 1% of those people who get infected, not very sick, but get infected, there's 224,000 Californians that are expected to pass away because of this disease. Just recently, the United States surpassed 10,000 deaths, right? And that number is climbing quickly. I think New York registered just the other day 736 deaths, which is terrifying, right? This is going to change our family structures. By the time it is over, you know, the president said it, although, but also the governors are saying it as well. By the time that this is over, not a single person in this country will not know someone who was infected or passed away from COVID. Since this started, my family and I know at least 3 people who have passed away from COVID. Not all of them old, right, as the original idea was, and several more people who have been infected. And so I know firsthand exactly how this virus is impacting people's families and communities. So that's sort of how this webinar was born, the need and necessity to share this information. All right, so there are millions of people in this country who are going bankrupt due to crushing medical expenses, which we can only expect are going to get worse. While it's great that we've heard from the federal government that COVID testing is going to be free, what we've also heard is stories coming out about people who have been treated for COVID, whose insurance companies didn't fully pay for their care, and they're leaving with $30,000 and $40,000 in medical expenses. At a time when most people aren't working, we can only expect these numbers are going to go up. Last week, and I guess it was, you know, about a week and a half ago or so, the CDC reported that 38% of all people sick enough to be hospitalized were between the ages of 20 and 54. The original reports that this was only affecting sort of the baby boomer generation, that they were the only ones who were being seriously affected by this disease, were just wrong. Some experts have suggested that because China and Italy have older populations, that the numbers were skewed as to how much this is affecting young people. So much so that I believe California registered its first death of an infant, and I think it was Florida registered the death of a 12-year-old. So we are starting to see real numbers about how this virus is affecting us. I also just recently read a report that we have about 8 different strains now. There are 2 main ones that we're still talking about, S and L, but that there are about 8 different strains of this virus. So it is mutating, it is changing, and we will be seeing more of that mutation as we go along, I presume. People always say to us, I never thought it could happen to me. And generally, when we talk about that, they say it in such a way of, like, I just knew they had this in order. Or I just knew that they had thought about it and taken care of it, so I didn't have to think about it. They never thought that it would happen to them. It's always somebody else. And we want to really encourage you to think that this really could happen to you. And the numbers are suggesting, specifically related to COVID, that this could be a problem for each and every one of us. So who am I? My name is Portia Wood. I've been an attorney at law since 2011. I have my BA in journalism from Cal State Northridge, a JD from the University of Maryland School of Law. Oh, this is a tongue twister. And a dual LLM from Pepperdine University School of Law. I am founding partner of Wood Legal Group LLP, along with my mother, Robin Wood, who's also an attorney. We are members of the American Academy of Estate Planning Attorneys. I'm 2017, 2018, 2019, and just recently 2020, top 40 under 40 for the National Black Lawyers Association for California. And I'm a mom to a 2-year-old son who is really the reason why I do this work at all. And that's my cutie pie baby right there. But for me, he is why I do this. I have a keen understanding of what it means to need to have a plan in place to ensure that my minor child is taken care of and that everything that I'm working for is going to go to support him. Answering the question of who will take care of him if something happens to me was also a big part of this, as well as how do we protect family wealth in general. Right. So what are your planning options? There are really 4 different types of planning options that you can have. You can have no plan at all. And if you guys are willing, would you be willing to put into the comments or into the chat how many of you have no plan at all? I can make it private if that would be easier for people here. I'll make it private and then you can just tell me, because it'd be interesting to know how many of you feel like you have no plan at all? Okay, wow. So there are about 12 of you who answered that question, and most of you said you have no plan at all. What I want to tell you is that it's actually not true. Everybody has an estate plan, right? Everybody has an estate plan. What you have is either you have a plan that you have written yourself that says where your stuff goes and who manages your affairs if you can't, or you have the plan that the state has written out for you. But everybody has an estate plan. And so we put that on there sort of to trip people up, because we do need you to know that there is a plan in place for you. It is either the one you wrote or the one that the state has decided works. And if you use the state's plan, you have to go through the court process, which is either living probate, which is guardianship, a guardianship proceeding, or death probate, or both. And death probate being when you pass away, the courts are sort of deciding where your assets go and how to pay your debts, etc. If you are left or leaving your estate to the state's plan, they are going to charge you to use their plan. And we'll talk a little bit more about that in a second. The second planning option is a will. A will is a really great estate planning tool depending on your asset level. Most people think a will is all they need, and the majority of the United States needs far more than a will. In California, if your estate is $166,000 gross, so everything you own, regardless of how much debt there is, if it's over that amount or you own real estate, a will is insufficient to pass your assets, because you would still need to go to a probate process. If you're above that threshold, you must have a trust to avoid probate. That's the minimum. In a state like Maryland, if there are more beneficiaries than just a spouse, the threshold is $50,000 gross. If the sole beneficiary is a spouse, it's $100,000 gross. Most people meet these thresholds, right? You start adding up retirement accounts, bank accounts, cars, clothes, jewelry, artwork, life insurance. You start adding up all of these pieces of your estate, and you end up realizing that you're far more than you think you do, regardless of how much debt there is. The second thing is a living trust, which Typically we talk about it as a probate avoidance trust, which can be an excellent estate planning tool. I don't recommend a living trust if you have minor children, because what that does typically is avoids the probate process. So we solve one problem. It gives all of the assets to your children at the time they turn 18. And the people who manage those assets are typically whoever their guardians are. And so if you want to have some say over how those resources are spent, that's not going to be a good plan for you. And the last one is legacy wealth planning. When we talk about that as planning for 2 generations beyond yourself, right? So your kids and your grandkids, minimizing taxes, etc. So what is court interference, right? The first mistake people make in their estate plan is not having something in place to protect against court interference. I don't know about you guys, but there have not been a lot of times in history when the courts have been great for people, right? So leaving everything you've worked for in the hands of a judge to decide how your family gets it and when is probably not the best plan. Now, in this current moment, the other issue is the courts aren't really open, right? They are operating at limited capacity across the country. And so if you needed to go to a living probate or a death probate for your family to get access to your bank accounts, to be able to pay your bills or to call Social Security on your behalf, if you were incapacitated, they would have to go to the court to ask for permission to be able to access any of your accounts. If the courts aren't open, they're going to be waiting for a really long time. And that could be desperately needed resources. So what is living probate? Living probate is when the courts are in control, right? It's when you are incapacitated or unable to handle your own affairs, and someone in your family or friend group is asking the court for permission to handle your affairs for you. That's your personal affairs as well as your healthcare affairs. So if you're in the ICU and you are severely sick and you can't make medical decisions for yourself, who makes those decisions for you? People always wrongfully believe that their spouse is the person who makes those decisions. And the fact of the matter is, just because you said I do does not mean that they now get to decide whether you stay on a respirator or not, or if you get an experimental treatment or not, or if they get access to a bank account that you did not give them access to during life. And people say to me all the time, they go, that doesn't make any sense. We're married. But it makes perfect sense. If you didn't give them access during your lifetime or when you were capable of giving them access, why would they automatically have access to your account or to make medical decisions when you can't have a say anymore? Courts don't do that. And if you want to think about how this played out in real life, in the late 90s, I believe, early 2000s, we had the Terry Schiavo case. Terry Schiavo was recently married, a couple years into her marriage, and she ended up in a vegetative state. And her husband said, oh, she wouldn't want to live like this. We should take her off the ventilators. We should take her off and let her pass away. And her parents, who thought that perhaps her husband had something to do with her becoming incapacitated, right, thought he was being violent with her, said, no, she would want an opportunity to fight. They then sued each other for the right to make that decision because neither one of them was in a superior position to the other. So they sued each other. The case went all the way up to the Supreme Court, and the Supreme Court essentially punted it. They said every adult, so everybody over the age of 18, needs to make that choice for themselves. It is not the court's position to say that a parent has a superior claim than a spouse or vice versa, because not everybody has a nice spouse and not everybody has nice parents. So we're not going to say that. People over the age of 18 have to say that for themselves. So next is time consuming, and it's even more time consuming now to go to a living probate because the courts aren't fully operational. So if you were an emergency and we needed to get to some emergent access, we wouldn't be able to do it. There would be no way to effectively do it at this point. Once it does happen, your personal information would be disclosed. It's a public process and public proceeding, so what you own, why you're incapacitated, all of that becomes a part of the permanent record. And it's expensive, right? The court is going to charge you for using them to be the person who decides. There will be court fees, there will be attorney fees, there will be accounting fees. There are also conservative fees. The people who are in charge of taking care of you also get paid out of your estate. The next is if you should pass away, then there is a death probate. If you don't have the appropriate documents for your estate, there is a death probate. Again, this is time consuming. Even before we had this pandemic, the probate court was operating at about 12, 18 months an uncontested estate. And there are some estates that are still going, and it's about 15 years later. Just imagine the backlog we're going to have now that we don't have a fully open court system. It is also expensive. The court fees are costly, right? But you're putting the court in charge. You have to have publication and bond fees. You have to publish in a court, or excuse me, in a newspaper of general circulation for 4 weeks that you've died, that an estate is being opened. Executor and attorney's fees are set by statute. If you have $1 million estate in California, remember everything you own, regardless of how much you owe, your attorney's fees and executor fees are going to be about $24,000, and that's assuming nobody fights. If people start fighting over your estate, it's an additional extraordinary fee that the attorneys can take on top of that statutory fee. Best estimates are about 30% of your estate may get lost in the probate process in fees. But what happens is the courts get involved because we haven't made a decision about where our estate should go. And we haven't set it up appropriately. And so when we're thinking about this crisis and we're looking at these numbers, we're saying 1% of the United States passed away from COVID. It's a huge wealth redistribution happening in this country in a very short period of time. Does it go to the families to support us, or is it going to be locked up in a court process? So that's one of the things that we want to think about. If you have property in multiple states, you will need to have a probate in every single state in which you own property, and have an attorney in every single state, because most attorneys can't cross boundaries based on their licensing. So the next one is retirement plan protection. People have the wrong selections for IRAs and 401ks. Again, in this current moment, right, this was always important to make sure you were watching, but in this current moment, we are looking at it in the next 18 months, a significant change in our society. And we need to be looking at what retirement plan elections do we have in place? Do we have the wrong options selected for our IRAs and our 401ks? Are we taking out of our IRAs and 401ks right now? Under the CARES Act, if you are in a financial bind, you may be able to take money out of your 401k or your IRA, despite the fact that you are not 59 and a half. If that is true, and that's something that you need to do, you need to talk to a financial advisor to make sure that that's going to be the right move for you. Also, how many of you guys have heard of the Secure Act? Sorry, I made the chat private so that only I could see it, but how many of you guys have heard about the Secure Act, which passed in December of 2019? Okay, so not many of you. The Secure Act made changes to our retirement accounts. If you are 70 and you're still working, then the Secure Act was a great thing for you. It allows you to continue putting money into your 401k until you're about 72, as long as you have earned income, which is great. It allows you to keep building without having to take the mandatory distributions. Your spouse still takes basically the same way, so there's no real change to you during life. Big change came in for the kids, for my generation. We used to be able to get what is called a lifetime stretch on those retirement accounts, where if our parents passed away and they had a retirement account, we could elect to roll it over into an inherited account and take a stretch. We would do required mandatory minimum distributions until we reached 70 and a half, and we had to start taking mandatory maximum distributions. But over that time, that money is growing tax deferred or tax free, depending on the account, for our lifetime. So if you're 30 when you inherited, by the time you're 70, it's probably worth multiples more than what it was when you first inherited it. Pretty nice, right? Well, in 2019, December, effective January 1, 2020, this administration in a bipartisan act changed all of that. We now will be required to take any amount of a retirement account out in full within 10 years. And what that means for us is that we will likely be in our highest earning capacity, the highest tax bracket, when we take that money out, which means we're going to lose it, which means we need to be looking at our retirement plans and talking to our parents about their retirement plans and making some changes to make sure we're maximizing the amount of money that will come to us and minimizing the amount of taxes and fees that are going to go to the government. Nursing home protection, this is not a big one that people are worrying about right now in this crisis, but I will talk about it a little bit. Right? The average cost of a single room in a nursing home is about $116,000 a year. You just want to make sure that inside of your estate plan, you have language that will allow your successor trustee, if you become incapacitated, to do some nursing home protection planning. 5 ways that you can pay for long-term care, in case you guys don't know. 1, use your own money. 2, you can buy long-term care insurance, which doesn't really exist anymore. In California, there's only 2 companies that do it. Extremely expensive. The premiums can increase every single year. And they won't give it to you if you're under 40 or if you're over a certain age, right? I tried to get it and they told me that I couldn't because I was too young. But hybrid insurance is a new product that's sort of being touted as a guaranteed use product. This is something you should talk to an insurance agent about or a financial advisor about. But from my understanding, the way that it works is that you have a life insurance pot and you have a long-term care pot. And if you use the long-term care while you're alive, you reduce the benefit on your life insurance for what goes to your beneficiaries. If you don't use the long-term care, then you have your life insurance pot that then passes on. So you get something for what you've paid in. You can apply for limited Medicare benefits, which cover a maximum of 100 days. It's the first 20 days at 100% and the remaining 80 days at a fraction. This is not going to work out well for people who need to be in a nursing home. By the way, the average is 2.5 years, so it's not going to work out so well. You can become eligible for Medi-Cal or Medicaid benefits. Medicaid and Medi-Cal are essentially the same thing. Medi-Cal is the name of the program in California because we just dare to be different. I don't know. California has to be in its own sort of world, but it is essentially the same program. And so if you are applying for that, you need to have spent all of your own money first. It is a means test. They check to see, do you have any money? Now, they will not make you sell your family home if you qualify, right? So your spouse can stay in the family home. Once both spouses pass away, before the house can pass to your beneficiaries, they present a bill to your estate and they say, here's what we spent on their care. You need to either refinance this asset or pay us cash. If not, the government will sell that home, pay off that debt, and then give your beneficiaries whatever is left over. How many of you guys know anybody who's been through the Medi-Cal recovery process? Oh, a couple people. Do any of you know anybody with coronavirus? And I'm putting some of those into the polls. All right, so the last one is you qualify for veteran aid and attendance benefits, which can be really great, but it is a complicated process. So we can talk a little bit about that offline if you think you qualify. The next one is divorce, creditor, and lawsuit protection for beneficiaries and heirs. I know some of you guys, because I can see you, some of you guys have children and minor children specifically. If you were to get sick and pass away during this period of time, the plan you have in place today will be the one that lasts for their lifetime. So whatever you've planned for in this moment is what they will have to live with, good, bad, or indifferent, right? If it's the state's plan, they will have to deal with that. If it's a complete, complex, comprehensive plan, that's what they'll have to deal with. It's whatever you give them. Divorce, creditor, and lawsuit protection is something that can only come from you or the generation above you. Your parents can give it to them, or you can give it to them. They cannot give it to themselves. Once you put it into their estate, they can't then say, oh, I don't want it, and take it out and put it somewhere else to get it protected. But you can do that. So if your kids were to get divorced, do you want those assets going with the departing spouse? Maybe you don't care, or maybe not. The question that comes in is that have you thought about it? My son is 2. And when I think about it, I go, oh my gosh, I'm planning for his eventual divorce. What's wrong with me? But I have to, because if something happens to me tomorrow, despite the fact that he's 2, one day he'll be 30 or 35, and one day he might be married, and one day he might get divorced. And whatever plan I put in place today is the one that is going to govern him when those life things happen. And so I have to think about them and decide what makes sense for my goals, my estate. The other thing is predators and opportunists. If you leave your estate susceptible to the state's plan, I mentioned it, it's all public, which means I can go to the court and ask for a copy of that probate list, and I can find every estate that has real estate in it. I can find out who all of your beneficiaries are. I can find out how much money they've inherited, when they got it, when they get it. And all I have to do is knock. I have this amazing business opportunity for you. It's only going to cost you, $200,000, and wouldn't luck have it, you just inherited $300,000. At 18, it might have sounded like a good deal. I'm going to get you a 35% return on your money. Look at how much money you can make, right? This is things that we see that happen. Also, kids get in trouble with money and lawsuits. With money, they get lawsuits, they have creditors. Student loan debt is a huge issue for millennials and, what are we, Gen Y, right? The student loan debt is a thing, unless they decide to forgive it at some point. We're stuck with it. And if you leave money directly to your kids or to your beneficiaries, and they have student loan debt, and they're on an income-based repayment or anything like that, you will be affecting their payment, right? And the last thing is financial immaturity. Would you be ready to give somebody $400,000? Like at 18, at 20, at 25? I wouldn't give my son that. So divorce protection, you can put that in there by creating an estate where your assets are set aside and it's for your child's benefit, not theirs. It has a separate tax ID number, not related to their social security number. You can protect those assets. You can also protect them from lawsuit expenses. I know in this slide we're talking about cars, but in reality, if you're in a position that gets sued all the time, right? Surgeons get sued all the time. Police officers get sued all the time. If your child or your beneficiary is in a profession that might get sued, would you want the assets that you've worked for to be at risk? So I put the poll out, what is living probate? Living probate is the court proceeding for asking someone to be a guardian, right? So you are incapacitated, you're in the hospital, you're in the ICU, and you can't handle your own affairs. You're not capable. Another situation would be, you have a stroke, you're in a car accident, and you're in a coma. Someone has to be, picked to handle your affairs for you. And if you haven't done a directive that says who that person should be, you have to go to a process called living probate, also known as a guardianship or conservatorship proceeding. So that's what it is. And hopefully that helped you guys out who weren't sure. The The other thing, financial immaturity. Would you have been responsible with $400,000 if it was given to you at 18 or at 20 or at 25, right? Not just that somebody gave it to you, but that somebody that you love died in order for you to receive that. What we know from psychology is that when you didn't have to work for it, you typically don't respect it as much. But also when we're grieving and we have money, we tend to do things like buy, right? We go out and we shop and we buy things. And then just briefly after that, we get something called buyer's remorse, where we're looking at this stuff that's not worth what we just paid for it. We don't have any more money and we're still technically sad. It's probably been compounded because now we also are broke, right? Financial maturity is not just about 18 and 20-year-olds. We see this pattern with 40-year-olds and 50-year-olds and 60-year-olds, some of whom will take an inheritance and immediately pay off debt, which sounds like a really logical thing to do. It might be, depending on what the debt situation is and what the interest rates, et cetera. But typically, it's a terrible idea because you haven't actually changed the behavior that got you into debt in the first place. And now you don't have any money that could have been getting a return. And the next is family fighting. Not having something in your plan for dealing with family fighting about money. In a time like right now, where tensions are already high, people are already in the house trying to figure it out, you add on the added stress of a family member getting ill, or seriously ill, or passing away unexpectedly in this situation, right? And then there's no plan for what happens with everything that they've worked for. All you're going to see is more family fighting. And typically what that leads to is lawsuits. And so we want to make sure that our plans and the plans we have in place are dealing with this. It's not just money that I want you to think about. It's stuff. It's that piece of artwork on your wall that, maybe it's not worth that much money, but it's sentimental. Sentimental items are the things that lead a lot of people into court, and we do mediation in our office as well. And we'll see these fights over sentimental items. Mom's wedding ring that there's only one of. Dad's watch. The old Mustang that we tinkered with when we were kids. Things that are only one that you can't just, split in half. Those are the things that you need to think about and then make a plan for. So legacy protection, this is one that, complicates people a little bit when I say it, because they go, what do you mean? How do I leave a legacy? I'm leaving money. But we are more than just our money. Like, we are our wisdom, our values, our life lessons, our experiences. Yes, we are not here, but our money and our estate is. We should be using our estate to further show our values. For me, I think education is important. And if I'm not here to teach my son or encourage my son to continue on a path towards education, then my money has to do it. My estate has to do it. I have to incentivize him and disincentivize him to do things. So the first one, if you graduate from high school with a certain GPA, 4.0 or above, depending on the scale, then you get this little sum of money that you can go and do whatever you want with between high school and college. My encouragement is that you go and travel and see the world and experience things in a new sort of learning way. That's me showing him my values in traveling as well as education. If you do well, I will support you and I will encourage you. If you get a free ride to college, etc., same kind of thing. You get additional money that will be just for you to decide, unrestricted of my plan, to make those decisions. Now, there's also the flip side of that. If you are subject to undue influence from drugs and alcohol or people, you will not control the resources that are there. So incentivizing as well as showing, what my values are. I've had clients who have said things in their plan, which is hard to put into place, but they wanted their plan to say it, was that if their daughter ever started smoking, a portion of her estate every year would go to the American Cancer Society until it's all gone or she stopped smoking. And even though they knew that that would be a hard thing to enforce, they wanted it in the plan to show their daughter just how important it was to them that she never start smoking, because both of their grandmothers had died from lung cancer. So they said, if we're not here to tell her that, we need this plan to tell her, because that's what's left is our stuff. So remarriage protection. This is kind of the final one. Nobody ever thinks that their spouse would get remarried after they pass away, or that they would get remarried if their spouse were to pass away. What studies show us is that that is not true. We are more likely, especially younger people, to get remarried if our spouses were to pass away. Our spouses are far more likely to get remarried if we were to pass away. Most people don't want to be alone forever. And nor should they. Life is for the living, right? But if your plan doesn't address your spouse getting remarried at some point in time, particularly in this moment where so many people are expected to pass away, we need to address remarriage protection, because a stepchild cannot inherit from a stepparent without documents. They are not a part of the state's plan. They are not a part of the line of succession. And so if you are in a blended family now, or you just want to make sure that your plan addresses, should your spouse or you be in a blended family later, you have to have remarriage protection inside of your plan. You have to consider it. And it's hard, right? People don't want to think about their spouse getting remarried or their children being raised by someone else. But it is a possibility and a consideration that we need to look into and make sure our plans are addressing. Because if we don't, our children could be disinherited. And I don't know about you, but I don't get up and go to work every day so that my son will be disinherited. And I'm pretty sure that you don't go to work every day so that your spouse's new spouse can get everything that you work for and your kids get nothing. So we have to consider what would happen in that instance, whether or not we believe that would happen at all. So what is the summary of an ineffective plan? No living or death probate protection, no nursing home cost protection, no retirement plan protection, no lawsuit creditor or divorce protection for kids, no protection with sort of DIY and bare bones plans, no ways to preserve life value stories and avoiding family feuds, and then no remarriage protection. I just want to challenge you guys to sort of ask yourself, what is most valuable to you? Most people tell us it's family, it's health, it's friends, it's their values, their skills, their relationships, those sorts of things. And so we firmly believe that your plan should represent what's most valuable to you, which is why no two plans can be alike. What if things change? Things always are going to change. Three main types of changes that you need to think about are law changes, changes in your family structure, and new legal strategies, right? You'll want to keep your plan up to date. In our office, we reach out to our clients every single year just to see if anything has changed. Check in with them, have you started a new business, had a new baby, has anyone passed away, etc. We want to make sure that they're telling us every 5 years you should be reviewing your plan and making sure that it's still current under the law and still does what you think it does. So our question is, how will you sort of protect your family? What we see that most people are leaving behind, the numbers are something like 70% either have the wrong estate plan or no estate plan in place, no estate plan that they've written in place. So they sort of leave behind family disputes, court hassles, fees, unnecessary taxes. So what I would encourage you to think about is that you can leave behind planning that works, right? You really can. It just takes some time to think about it. We are all at home anyway. So while we have this moment of silence, let's really map out what we would want to see happen with everything we've worked for if something were to happen to us. And there's no better time than right now, because the threat is real. I mean, it's always been real, but now it's in our faces and in our homes. And so we need to make sure that we have at least the basics. Basic estate planning documents that everybody over the age of 18 needs is your advanced healthcare directive. It says, what do you want to have happen if you are incapacitated? If you're on a ventilator, how long do you want to be there? Do you want them to pull the plug immediately if there is a medical certainty that you won't recover? Or do you want them to leave you on there? What are your wishes? Would you want to be an organ donor? Who should make those decisions? Would you want pain medication, even if that medication meant that it would hasten your death, i.e. morphine, end of life care? Who makes those medical decisions for you? Your healthcare power of attorney. Who is the person that says what should happen and is legally authorized to say what should happen if you can't say for yourself? That's important. Who gets to decide? And don't just pick one person. You need to pick 3 to 5 people. That's always my recommendation. Because A, you never know what's going to happen in that person's life at the time the documents need to be used. And in this climate right now, you don't know who will get sick and who won't. So if your first choice isn't available, now we got to go to court because you don't have a second choice. Have 3 to 5 people that you would be comfortable making those decisions for you. That way, if the first person isn't available for some reason, you've got a backup and a backup to your backup. You also need to have your HIPAA authorization form. This is a document that allows your healthcare agent the right to look at your medical records. What good is having a healthcare agent if they don't know where you've been or what your medical journey has been? They need to be able to make informed decisions for you. The next is your property power of attorney. And this could be the same person as your healthcare agent. It could also be different people. Still 3 to 5 at least, right? At least 3, probably don't need any more than 5. But this is the person who controls you. All this magic, right? Your money, your bank accounts, can pay your rent or mortgage, is able to contact, say, Social Security on your behalf, contact your healthcare provider and negotiate on the legal aspects. They'd be able to start a lawsuit or sue someone on your behalf or defend a lawsuit if they needed to. They're the person who controls this. Right? At the very least, everybody needs to have a will. Everybody over the age of 18 needs to have a will. Those are the basic estate planning sort of documents. Your healthcare directives, which encompasses all of the directives that I just talked about, your property powers of attorney, and your will. Because those are the things that are going to allow your family to act, or your friends, depending on who you've picked, immediately, in the event something happens to you, without having to ask the courts for permission. Okay. If you have minor children, you also need to have an emergency or temporary guardianship form, as well as an emergency/temporary healthcare form for your children. Because if you aren't capable of making their healthcare decisions, who makes them on their behalf? Who can legally have them if you are not capable of taking care of them in that moment? And hint, it's not your parents and it's not your siblings. Those are not legally authorized guardians. If you have minor kids, we're actually going to go more in depth in estate planning with minor children tomorrow on our webinar. It's 11:30 Pacific, 2:30 Eastern. And that webinar is specifically about estate planning if you have minor children. It is very different, the considerations. But anyway, those are the documents that you need to have in place in basic estate planning. If you would like to avoid probate on your passing, et cetera, you can start to get more complex in what your estate plan looks like. So the reasons why people don't plan that we've learned, procrastination is number 1, right? You just think that you're always going to have time. I am urging you to do something today, right? Get it done, get it in writing, get it done today, because we just don't know what tomorrow is going to bring, and it is not guaranteed for any of us. Second reason is in lack of knowledge, right? The laws are continuing to change. We just don't know what we don't know, and we don't know where to start. You now know where to start with your estate plan, where to start thinking, what to start thinking about. I urge you again, please go get this done somewhere. And again, what's the most important part of planning is making sure that what's important to you is covered. So thank you guys so much for joining me. I want to go ahead and take your questions. If you have any, please make them general, like I said, but I would be happy to answer